What's going on, good people? It is the Bad Wolf. This is the fifth part of Right to Travel, the complete breakdown on the legal level, the legal guide. Obviously, we'll need to make another updated video on all the tips, tricks, techniques, how to do, and then that particular Right to Travel video will be the last one pertaining to Right to Travel. That's it. So, do not forget to hit that bell, like, subscribe. This video will link probably back to the first video. That pop-up will pop in the upper right corner at the video's end within the last 20 or 30 seconds. And it'll allow you to go back through the whole series and listen to it and watch it and, learn if you want to. If not, hey, do your thing. Do that damn thing. Okay, man? There we go. All right. So as always, donations are welcome. Feel free to hit blacksite32.com. You can join the Wolf Pack on my main YouTube channel. Be aware of anybody trying to scam you, pretending to be me by misspelling my name or something similar, because people do that. If anybody's asking you for money, pictures, your horoscope, financial information to invest, it's not me. Everything is done through BlackSite32, including my names of my official names and locations on the various media channels. Do not send anybody anything. I will not ask you to do anything other than here in my videos and then on blacksite32.com. That is it. All right. With that being said, let's get into it. As always, if you see anybody using any of my images, information, any illegal, nefarious, criminal purposes whatsoever, even talking smack, I don't know why they want my in their mouth, but hey, I guess it is what it is. Enjoy yourself. Knock yourself out, little buddy. But in all seriousness, yes, report them for bullying, slander, and defamation of character. That being said, I just want to let you guys know I appreciate you guys for learning this. This is stuff I do already in my normal private capacity. Just literally showing you guys what I find in their books. Very, few people really want to learn all this, so I appreciate you guys for learning. Now, let's get to the video.
A claim may be laid that RCW 46.20 is void for vagueness as being overbroad, similarly void for want of due process, similarly facially void and as applied void. This can...
All right, hold on. Let me, it's like the video was off from the text, so I'll try it again.
A claim may be laid that RCW 46.20 is void for vagueness as being overbroad, similarly void for want of due process, similarly facially void and as applied void. This can be articulated by demanding the state to provide the section of the Act that provides substantive notice of its application to personal use of personal automobiles, same, by demanding the state to provide the section of the Act that provides procedural protections of its application to personal use of personal automobiles. If the state cannot provide these sections, then the statute must be void, as overly broad in its intent and application, for want of clear, concise, and express terms. The power of the state to license, and further regulate, through a driver license, private affairs, is non-existent. It has been laid down as a general rule that if the power of the state to control its highways has not been delegated, and the state has prescribed no conditions limiting or regulating the use of the highway, the people are at liberty to use it for travel, transportation, and communication, by any lawful means, subject only to the condition that such use neither interfere with other or similar lawful uses of the way nor invade the rights of the owners of abutting lands. 25 AM Jure Highways Section 169, citing State ex rel. Bartlett v. Weber, 88 Con 175, 127 p. 536. The Washington State Supreme Court has already made it clear in the following case that the driver license is intended to apply only to for-hire vehicles. The International Motor Transit Company case below must be read in pari materia with the rules of municipal regulation. Sector 103, it shall be unlawful for any person to drive an automobile or other motor vehicle carrying passengers for hire, within the city of Seattle, without having a valid and subsisting license so to do, to be known as a driver's license. Driver's license, first class shall entitle the holder thereof to drive any kind or class of motor vehicles for hire within the city of Seattle. Driver's license, second class shall be limited to stages, sightseeing cars, or other motor vehicles operating over a specified route and having a fixed terminal. Driver's license, third class shall be limited to drivers of taxicabs, for-hire cars, or other automobiles not operating on fixed routes, and having a passenger capacity of less than 7 persons, not including the driver. It is intended to apply to for-hire vehicles as provided in Section 6313, Remington Comp. Stats, are defined to mean all motor vehicles other than automobile stages used for the transportation of persons for which remuneration of any kind is received, either directly or indirectly. International Motor Transit Company v. Seattle 141 Wash 194, 251 p. 120. As noted previously and further in this section, the requirement of a driver license is for the operation and conduct of a business. The research compiling this section procured no evidence anywhere, not in any state or federal regulation or judicial opinion which extends the state authority in Title 46 RCW to the common man, requiring a driver license to the use of a personal automobile to conduct personal affairs. A state is within its police power by requiring a license as a prerequisite to the carrying on of certain activities commonly designated as businesses, occupations, professions, trades or callings. 51 AM Jure 2D licenses and permits Section 14. States have broad powers to regulate and license the practice of the professions. National Pharmacies Incorporated v. de Malesio 51F, Sup. 2D 45. It is seemingly proper to reiterate the definition of the term license, as the definition of this word will be important in understanding the statutes as they are properly applied. The permission, by competent authority to do an act which without permission, would be illegal, a trespass, or a tort. People v. Henderson 391 Michigan 612, 218 NW.2D2. Leave to do a thing which licensor could prevent. Western Electric Company v. Packent Reproducer Corporation. 42F.2D 116. For this definition to apply to a common traveler, a state would have to take up the position that the exercise of a protected right to use the public roads, in the ordinary course of life and business, is illegal, a trespass, or a tort, which a state could then regulate or prevent. This position would raise fundamental questions, as this position would be diametrically opposed to constitutional law. As recognized in this writing, the proper definition of a license is a permit, granted by an appropriate governmental body, generally for consideration, to a person, firm, or corporation, to pursue some occupation or to carry on some business which is subject to regulation under the police power. Rosenblatt v. California State Board of Pharmacy. 69 calories, app, 2D 199,158 p.2D 199. Curiosity alone should question the authority of a state to impugn one for not having a public license for travel in the private. What reason could the legislature have, not to include language, and in the history of amended legislation, purposefully delete such terms as business, if it were not to confuse, and manifest a clandestine subterfuge of fraudulently created businesses, which then a state could regulate? What the state may not do directly, it may not do indirectly. Bailey v. Alabama, 219 U.S. 219, 31 SCT 145, 55 L. ed. 191. A license fee is a charge made primarily for regulation, with the fee to cover costs and expenses of supervision or regulation. State v. Jackman 60 WISC.2D 700, 211 NW.2D 480, 487. Shown above are the fundaments of a driver license. One court called out the distinction, in discussing the public health and welfare, as that being the use of the highway by travelers is usually a short trip with a single departure point and a single termination point, limiting the amount of time on the highway. Where in contrast, a driver for hire or other occupation or profession may spend several hours or days traveling public easements with several intermittent stops, whereby creating greater liability to other travelers. Certainly, the operation of business on public roads and streets by those individuals who use the highways in excess should be required to pay a highway or tonnage tax. What was spuriously deleted from the Motor Vehicle Act reformation in the 1960s is the term chauffeur, discussed infra. It is the chauffeur that is the subject of a basic driver license, notwithstanding other delivery-type occupations. The Latin term nullum simile est idem, things that are similar are not the same, is the suspect of a claim of void, as to RCW 46.20. See RCW 46.20.055 for similar definitions following. Huddy on Automobiles 6th ed., Section 225. Excerpt from John MacArthur McGuire, Harvard Legal Essays, citing State v. Gowdy 62 Montana 119, 203 Pac 1115, see also Forthorpe 2324. Here we start to see the courts express the original intent of the statutes, which the legislature has conveniently scripted, classifying types of drivers and the tax revenue generated by the business they execute in their use of the highways. The question may be asked, does a state have authority to classify personal conduct as a part of commerce like that of chauffeurs? No. Why? Because travelers don't collect a fee or charge a fare for traveling to visit the doctor, the veterinarian, the grocer, the hardware store, the beach, the coffee stand, a job, the bank, the school, other family, a restaurant, a sporting event, or to see a movie or attend a funeral, etc. Ipso facto, if no fee is collected for personal affairs, then the state cannot impose a tax, which is de facto revenue, which is one of several intents of regulation for Title 46 RCW. Earlier, we encountered, at AM Jure 2D Highways, Streets and Bridges Section 227 and Huddy on Automobiles Section 26, the term incidental. This term refers to the nature of commerce upon the highways. The courts, in their determination of the phrase incidental, have acknowledged the transpersonal hyperbolic legal reasoning behind licensing statutes. When we look at RCW 46.20, the licensing statute for the state of Washington, we find no notice of the personal private use versus the private for hire use that was formerly a part of the statute. The fundamental risk associated with unbridled license schemes is the inability to detect the extent of the licensing statute in the absence of a narrowly drawn objective and definite standards to guide the licensing authority. Whatever the motive which induced its legislative adoption, lack of strict legislative definition promulgates an overly broad legislative scheme and is therefore void for vagueness. The void for vagueness doctrine, on the front end, necessarily implies that the governmental intent of the statute must be made explicit in the text, not then subject to judicial or administrative construction. See generally 16 AAM Jure 2D Constitutional Law Section 527. However, in order to regulate, the government may impose a permit requirement, so long as the scheme does not delegate an overly broad licensing discretion to a governmental official. Therefore, any licensing scheme must be narrowly tailored to serve a significant governmental interest. 16 AAM Jure 2D Constitutional Law Section 527. So, the question comes, is RCW 46.20.001 narrowly tailored? No, it is not. This writer found the statute to be overly vague, and substantial research was needed to qualify the text and intent of the currently written statute. Ultimately, what was determined is that the currently written statute, including those prior, dating back to 1968, classifies every single man and woman desiring to use the public highways as a chauffeur aka driver for hire. RCW 46.20.001 reads in relevant part. 1. No person may drive a motor vehicle upon a highway in this state without first obtaining a valid driver's license issued to Washington residents under this chapter. 2. A person licensed as a driver under this chapter, A, may exercise the privilege upon all highways in this state, B, may not be required by a political subdivision to obtain any other license to exercise the privilege, and esse, may not have more than one valid driver's license at any time. The interesting similarities between RCW 46.20.001 and the pre-Reformation statutes are these: 1. A person licensed as a driver, 2. May not have more than one valid driver's license at any time. These sections as written are expositive of the spurious attempt of the legislature to conceal the actual purpose of the licensing statutes. Licensing statutes must provide notice as to purpose and intent, and the Washington state legislature has intentionally done exactly the opposite. So comes the question, is the state attempting to regulate personal use of personal property? Sure seems like it. Maybe the state would like to license and regulate the type of shoes a man can wear on the public easements. Sure, why not? It is established that many things qualify as vehicles, as in the lob case of a U.S. passport. The legislature can, in the exercise of its police power, regulate and require the licensure of professionals as it sees fit, but any law in furtherance of the police power must be reasonable and not arbitrary. 51 AM Jure 2D licenses and permits Section 14, citing Auto Reality Service Incorporated v. Brown 27 Ohio App, 2D Section 77, 272 GNI 2D 642, see also Ohio AGO 96-045. The means or mode of traveling may be subjected to reasonable regulations. Benning v. State 161 Vanuatu Vatu, 472, 641 A2D 757. As noted by the Benning Court, above, the state may regulate, for the safety of the public. See generally Huddy on Automobiles 6th ed., Section 86. Huddy on Automobile 6th ed., citing Chicago v. Banker 112 Ill App, 94. It is well settled that the equal protection of the 14th Amendment to the federal Constitution does not take from the state the right or power to classify the subject of legislation. It is only an arbitrary and unreasonable classification. Classifications to which there is no just difference or distinction between the class affected and others that is thus prohibited. Huddy on Automobiles 6th ed., Section 137, citing State v. Seattle Taxi Cab and Transfer Company 90 Washington 416, 156 Pac 837, Allen v. City of Bellingham 95 Washington 12, 163 Pac 18, McLaughlin v. City of Seattle 199 Pac 457. City of Chicago v. Gall 195 Ill App 41, see also Huddy on Automobiles 6th ed., Section 145. Huddy on Automobiles 9th ed., Section 27, Definitions. Huddy on Automobiles 9th ed., Section 238, citing matter of stork 167 calories, 294, 139 p. 694. Huddy on Automobiles 6th ed., Section 221. In 1968, a major reformation was undertaken affecting the motor vehicle acts of many states. Of special note here, as to the strict distinction of who must possess a driver license, in the latter half of paragraph 1 below, it is made clear that those chauffeur drivers currently in possession of a license will remain current until such time as they may come to renew subject to the new codification. Every driver license issued after 1968 is issued to a chauffeur or driver for hire, notwithstanding the substitution of the word driver in place of chauffeur. Prior to 1968, Chapter 6 provided for the issuance of operators' licenses and chauffeur license. This distinction was discontinued in 1968. In favor of licensure based on the type or general class of vehicles to be driven by the licensee. It is also suggested that each state consider adopting a law providing that all operators and chauffeurs' licenses issued prior to the effective date of the revised Chapter 6, 1968, shall remain valid until their normal date of expiration or the dates of expiration shown on such license cards. Further, Attention is directed to the fact that this section referring to any person driving any motor vehicle is sufficiently broad by reason of the definition of motor vehicle in Section 1 to 134. Uniform Vehicle Code and Model Traffic Ordinance, CH 6, 1968. Throughout the years of its existence, the code has reflected provisions of state driver licensing laws, and in turn many state laws have reflected the visions of the code. Although there has been less conformity with the code in driver licensing laws than in rules of the road, model traffic ordinance, nevertheless many state driver licensing laws can be categorized on the basis of similarity to a provision which is now or has been in the past a part of the Uniform Vehicle Code. Further, hence the development of the code should be of general interest in that it mirrors the evolution of driver licensing law in this country and may be helpful in improving or at least explaining existing laws. Driver Licensing Law Annotated, 1980, herein after DLLA, U.S. Department of Transportation. National Highway Traffic Safety Administration, see historical notes at preface. The state of Washington was a major supporter of the U.S.C. and MTO. The definition contained in the Federal Motor Vehicle Act is, not of irony, identical in the preceding reference to the DLLA, which uses the object definition of motor vehicle contained in Uniform Vehicle Code and Model Traffic Ordinance, Definitions Section 1-134 Motor Vehicle, which reads: every vehicle which is self-propelled and every vehicle which is propelled by electric power obtained from overhead trolley wires but not operated upon rails. What was done in the mid to late 60s, having several revisions to gain nationwide acceptance by 1968, was to combine the operator's license with the chauffeur's license, as a taxi cab company operating vehicles for hire and the drivers paid to transport people, creating one license. The term chauffeur, French in origin, was deleted and replaced with the English common term, driver. What did not happen, citing from the sources below, is the presumptive all-encompassing graft of every man and woman who may use their personal automobile and subject them to a driver license. Here, once again, deference to RCW 46.20.001 and the language thereto is prudent. Subchapter 2c reads, may not have more than one valid driver's license at any time. 40 years later, this statute bears a striking resemblance to the 1968 Uniform Vehicle Code. The code was extensively amended in 1968 to form the current Section 6-101 esse, by eliminating the operator-chauffeur distinction and by clearly applying the one license concept to all licenses issued under the code. DLLA Infra. Valid driver's license. In 1968, the code abandoned the distinction between operators and chauffeurs' licenses and combined these two categories into a single driver's licenses with classifications based upon the type of vehicle the licensee is qualified to drive. 31 jurisdictions follow this code concept by issuing just one basic driver's license and by not making the distinction between operators and chauffeurs. DLLA Suprasection 6-101A, including the state of Washington. The one license concept expresses that every person has but one privilege to drive and that no matter how many different types or classes of vehicles a licensee has been qualified to drive in his home state, all types and classes will be noted on one license card. The issuance of one license card to a person for a motorcycle, another card for a passenger car, and another for a tractor-semi-trailer combination is not recommended because of the inconvenience and enforcement difficulties that would result. DLLA Supra. Footnote 4 Section 6-101c. This annotation covers state laws which provide for license classification for special licensing based upon factors of vehicle type, or factors of vehicle use, to transport persons or property for compensation, or a combination of such factors. DLLA Suprasection 6-104, Statutory Annotation Subsection A. Washington is listed in this annotation. In Washington, the law provides that the Director of the Department of Lic. shall adopt rules and regulations and standards pertaining to a determination of what types of vehicles require special skills for the operations thereof, taking into consideration the extent to which a special knowledge of traffic laws pertaining to the type of vehicle and a special ability to maneuver such vehicles is necessary for the safe operation of the vehicle both alone and in relationship to other types of vehicles on the road. DLLA supersection 6-104 subsection B. Every time an executive employee stops, detains, interferes and harasses a traveler on the common highway, that employee invokes and uses commercial licensing policy to coerce the traveler into believing that the personal use of the common highways by personal automobile is illegal, and he has authority to deter such further conduct until such time as the policy is complied with. The illusion of the necessity of a license to use a personal automobile is per se banishment from the free use of the public highways. The state police stop people at random for traveling and issue traffic infractions for no valid operator's license, and arrest people, and impound their personal property for allegedly driving on a suspended license. For purpose of discussion, if an individual should have the unfortunate circumstance of not paying a traffic infraction, and as a consequence, perhaps the driver license is suspended or revoked, consider RCW 46.20.245, driving while license suspended. This statute penalizes the driver for traveling the common easements in a personal capacity, with a monetary fine and incarceration. This is done via presumption that because one was traveling the common highways, one must have been driving, by definition. The right to travel includes the freedom to enter and reside in any state, and a state law implicates that right when it actually deters such travel, when impeding travel is its primary objective, or when, as here, it uses a classification that penalizes the exercise of that right. When the latter is involved, heightened scrutiny of the law is required to determine its constitutionality, and the state must come forward with a compelling justification. Emphasis mine. Attorney Gen of New York v. Soto Lopez, 476 U.S. 898, 1986, Eggert Edel v. City of Seattle Supra, Turner v. Fouché Infra, see also 39 Michigan Law Review 782. The decision in Dunn v. Bloomstein 405 U.S. 330, makes clear that the right to travel is, as a fundamental right, violated by classifications which penalize, not actually deter the right to travel, and the actual deterrence was not a factor to be considered in deciding whether a penalty was imposed. Eggert, Supra, citing Vaughn v. Bauer 313 F, Sup. 37C, also Turner v. Fouché Infra. The people have a right to travel, uninhibited, the common highways. That right is prejudicially barred when the state or local armed police stop and arrest based on a statute that is factually designed for compensatory drivers. Theft of a personal automobile is loss of personal property. While the personal automobile is in impound, an individual is forced to use alternate methods and modes of transportation. RCW 46.25 does not have a subchapter for the suspension of a commercial driver license. A suspension of a commercial driver license is effected through RCW 46.20.245. This represents proof positive that RCW 46.20 is in fact a commercial licensing statute. Other illustrations could be included, but it is readily apparent that when one is deprived of the use of his automobile today, for all practical purposes his mobility is seriously impaired. Admittedly, he may be able to locate public transportation, such as a taxi or a bus, but in many instances it will not be available when needed. Furthermore, as we have seen, the constitutional right of mobility is an individual, personal right which is not protected but, de facto, restricted if he is forced to use public transportation. A book, The Legal Nature of a Driver's License, John H. Reese. As a general rule, any law subjecting the exercise of liberty, such as the freedom of movement, to the prior restraint of a license, infringes that freedom. 16 AAM Jur 2D Constitutional Law Section 527. One's right to travel is severely limited if he is forced to constantly wait for buses or taxis, both of which would create a financial hardship. For then, the right to travel freely, with the usual and ordinary conveyance of the day, is then subject to a fee or fare, which is a state dictate for an individual to pay for a limited and restricted exercise of a right. Strict scrutiny is the most rigorous form of judicial review. In applying the strict scrutiny test, the Supreme Court has determined the right to travel, a fundamental right worthy of protection by strict scrutiny. Once a court determines that strict scrutiny must be applied, it is presumed that the law or policy is unconstitutional. The government has the burden of proving that its challenged policy is constitutional. To withstand strict scrutiny, the government must show that its policy is necessary to achieve a compelling state interest. If this is proved, the state must then demonstrate that the legislation is narrowly tailored to achieve the intended result. Here again we have the term narrowly tailored. So, does RCW 46.20 have a narrow state objective as to the licensing of drivers for hire? The answer is no. Can the statute distinguish the right to the use of a personal automobile in contrast to that of a driver for hire? No. This right to travel is a fundamental right subject to the strict scrutiny test under the United States Constitution. 16 BAM Jure 2D Constitutional Law Section 612. See also Johnson v. City of Opelousas 658F, 2D 1065. To be unconstitutional, the restrictions must prevent or limit a person's freedom of movement. 15 AAM Jure 2D, Commerce Section 97 and cases cited. Taking into consideration what has been discussed thus far, in order for the statute to have a valid objective, only two plausibilities exist. 1. When the personal automobile was purchased, the buyer was then obligated to hire a full-time driver subject to the license statute, for two reasons. A. Certainly one cannot pay himself to drive. B. If the buyer is the operator/driver, then he is required by law to obtain a business license and pay taxes to the Department of Revenue. 2. Every automobile dealership is in fact a de facto motor vehicle distributor wherein every vehicle purchased is actually a private for-hire vehicle and the purchaser is subject to the licensing statute. A partnership or corporation is not entitled to a motor vehicle license as such. They may register the machine in the corporate or partnership name, but the license must be issued to the person who operates it. Italic mine. The law applied to motor vehicles. Babbitt Section 86, at 143 citing, Emerson etc. Company via Pearson, 74 N.H. 22, 1906. However, for either of these to be true, the statute would have had to provide substantive notice of the license regulation at the time of purchase. Not likely, however, because as we have seen previously, the legislature has not specifically classified personal automobiles and the personal use thereof. RCW 46.20 is unconstitutionally vague as overly broad, facially void and as applied void because it allows the state to indiscriminately interfere in private affairs by using what has now been shown to be the driver for hire classification statute to inflict undue harassment, illegal fines, unlawful imprisonment and illegal seizure upon a common traveler, where no otherwise authority exists. To remain consistent, RCW 46.55.113 is also void as applied because this statute is an accessory to the fact of illegal enforcement, or when it uses any classification which it serves to penalize exercise of that right. 16 AAM Jure 2D Constitutional Law Section 576. See also Attorney General of New York v. Soto Lopez 476 U.S. 898. 106 SCT 2317, see also Johnson v. City of Opelousas. It is only after careful study of numerous fragmented statutes that it is determined the entirety of Title 46 RCW is an only for application to commerce upon the public highways and that all provisional clauses thereto can only be enforced to persons who use the highways in and for commercial trade for compensation. The activity licensed by state DMVs and in connection with which individuals must submit personal information to the DMV, the operation of motor vehicles is itself integrally related to interstate commerce. Seth Waxman, Solicitor General, U.S. Department of Justice. Brief for the petitioners. Reno v. Condon, number 98 to 1464, decided January 12, 2000, Supreme Court of the United States. RCW 46.25.080 License Contents, Classifications, Endorsements, Restrictions, Expiration, Exchange of Information. 1. The commercial driver's license must be marked Commercial Driver's License or CDL. A. Licenses may be classified as follows: 1. Class A, 2. Class B, 3. Class C. RCW 46.25.050 1. Commercial driver's license required, exceptions, restrictions, reciprocity. Drivers of commercial motor vehicles shall obtain a commercial driver's license as required under this chapter. However, this requirement does not apply to any person C. who is operating a recreational vehicle for non-commercial purposes.
Okay, pause. Oh, changed my shirt. Oh well. Now you guys can see that right there it said, so this goes out to my law enforcement peoples and all the rest of the municipalities and governments and agencies and whatnots and who's it's. You guys only have jurisdiction over the public, not the private, and you have it over commercial. The problem why it seems confusing to you guys, because you guys have been maui wowied to think that everything falls underneath your jurisdiction. It does the hell not. Much like as if I show up at your house at 2 o'clock in the morning and say, hey, judge, hey, police officer, hey, whatever. Can you file this for me? Can you do this thing? You're going to be like, bro, how do you know where I live? I would say the internet. And they would say, well, I'm not working. I'm off duty. I'm in my private capacity. My home is private. My family's private. I'm private. Oh, but see, the problem is that when they put on their badge and their garb and their little black dresses and whatever else, they're in public capacity. All they can see is public things. Public vision. That's all I can see, even though I've got a private side. I don't want to, and I can't recognize your private side because I'm in the public. So if you're private, you're invisible to me. That's the problem. But yet they took an oath to protect the people. They also took an oath to protect the bar. I do believe that is a qualified conflict of interest. But what do I know? All I can tell you is that there's things you guys don't know. There's things we all don't know. There's things I definitely don't know. But I do know these things that I'm talking about right here and right now. And that's why in everything that they do, it says public administration, not private. They have no jurisdiction over the private. Commerce, traffic, those are words for public things. Because I'm physically outside of my house does not mean I'm operating in public capacity. You can't take my private stuff and force me in my house, my car, my kids, my key, my everything to be in public. You can't force me into your jurisdiction. If I'm operating privately, which is what I am in my house, my car, my private conveyance, and you take that or you force me into the public or to sign anything against my will, that is joinder. That is a federal offense. You are not protected. Your, what is it, risk management department, your blanket policy, your individual policy, your insurance bonds, they're going to throw a hissy fit. Or as my mom would say, they're going to have a conniption fit Because anywhere where you deny me my rights, freedoms, and liberties, you're effed. But just wait, there's more. You as a police officer are also, or municipality, or individual, or judge, or lawyer, attorney, whatnot and what forth. Hell, even the mailman. Because I know some of you mail people watch my videos too. You guys are also protected by those same things, the states, constitutions, and qualified immunity, I believe. It's also limited. It's not 100%. So don't fall for the jazz, man. Because you can be sued. Depending on the egregious thing that you've done. Which is why you people out there need to be, whether anonymously or publicly, sending your right to travel documents to the legal department of the police station, to the police chief, the captain, district attorney, judge, mayor, alderman, attorney general. All of them need to know. They're not used to it. Now, your district attorney and a couple others like that, they know what it is. But there's no law across the board that says they have to tell you about it. And they're not. So that's why they just look at me as, oh, I'm simple. Fine. I'll be your huckleberry. I'll be your idiote, your idiot. Can't prosecute an idiot. Isn't that what they say in court? Black Law's Dictionary says an idiot or an idiota is somebody who is not clothed in office, public, and not subject to the jurisdiction thereof. So I'll be your huckleberry. Novus ordo secluum. Tempus fugits, my good man. Tabula rasa for those who speak Latin. Let's keep going. We're almost there.
Purposes. It is undisputed that all driver licenses are issued under RCW 46.20, even those issued to common carriers under RCW 46.25 and RCW 81 etc., as and for the purpose of trade, traffic, and transportation upon the public highways. Below is the implied exclusion rule. Notably, it is reasonably ascertainable that the statutes apply to drivers of businesses, thereto by implied exclusion. If the statute does not expressly include private travel, then it impliedly excludes it. And it is possible to argue that it is limiting only under the rule of express mention and implied exclusion. In State ex rel. Becker v. Wiley 16 WN 2D 340, 133 p. 2D, 507, this court said, with respect to that rule, the following. This rule should be applied only if and when it aids in determining legislative intent. In other words, the principle is to be used only as a means of ascertaining the legislative intent where it is doubtful, and not as a means of defeating the apparent intent of the legislature. King County Employees Association, et al. v. State Employees Retirement Board 54 WN.2D1. We cannot presume the legislature meant it to be applied to persons it specifically excluded. City of Seattle v. State, 103 WN2D 663, 678, 694 p.2D 641, 1985, 16 AAM. JUR. 2D Constitutional Law Section 218, at 109, 1998. Emphasis Mine. Hood Beverage Company v. Constellation Brands Incorporated. 149 WN.2D98, 2003. There is no such thing as a personal driver license. As shown previously, the legislature has seen to discuss general license schemes referencing RCW 46.20, as well as special commercial license under RCW 46.25 issued pursuant to RCW 46.20. But what is not discussed.
All right, so hold on. So they just said right here that there is no such thing as a personal driver's license. Why not? Because if it's personal, it's private. And if it's personal or private, you can make it yourself. But the problem is therein lies the word driver. And the word driver means occupation, for profit, commercial, public, regulated. It's their word. Don't take my stuff. So this is almost really an oxymoron. But you can have a driver who operates some, privately, like a chauffeur for a multimillionaire or somebody. It's a private or personal driver for them. But there's no such thing as a private driver's license, not even a private operator's permit on the private side. But like mine, I have a private traveler's ID that's good for land, sea, and air travel. Did you ever notice? Did you ever look on the passport card? I believe it's on the back where it says good for air, sea, and land travel. Well, travel, it's going from here to there. And what do they mean you need it on land? Other than for ID purposes. But why do they make it? Well, how do you travel on the water? In the air? Well, especially in the air, you're using a device unless you're an Elohim or a angel or a winged creature. So if you're in some machine in the air, I mean, I'd prefer a UFO. Wouldn't be my first time traveling in one, just saying. But if you're in that device and you're flying it, which most UFOs actually operate on AI, but anyway. But if you are, you're in a device. And the passport grants you the ability to be in it or to, well, not necessarily to fly because they do try to regulate it. But I would argue that if you know what you're doing, you can use your passport to fly a private device as well.
Discussed, neither is it written anywhere in the breadth of Title 46, is the term personal driver license. That term is likewise not discussed in the Washington Administrative Code or any other associative policy. However, it does further serve dogmatic, the whole act rule, which now undoubtedly has determined the driver license aka operator license to be a business license for compensation. Not to get lost in the vortex of commercial definitions, the state of Washington has declared by executive directive in the Administrative Code that driving is in fact driving a motor vehicle in commerce and that a person is deemed a commercial operator/driver. U.S.C. 308-100-005, 3, employee means any operator of a commercial motor vehicle, including full-time, regularly employed drivers, casual, intermittent, or occasional drivers, leased drivers and independent, owner-operator contractors, while in the course of operating a commercial motor vehicle, who are either directly employed by or under lease to an employer. U.S.C. 308-100-005, 10, street driving means driving a commercial motor vehicle on a public road, where the traffic laws are enforced, consisting of city street, country road, and freeway driving.
Once again here, the key word is driving. It's their word. If you're using their words and your stuff is registered to them, you are their property. You are a member of theirs. Like being blessed into a gang or jumped into a gang. call everybody, blood or this or that or whatever. My G, you're telling you get the tattoos and whatever else, you're a part of them. I mean, you can't be in a gang and then you're in the park doing hopscotch and you're I don't know, doing some soft stuff and you're like, oh man, I'm not a G right now, bro. No, as far as I was from what I was told, there is no downtime when you're a member of one of these things. But the public can be. Let me tell you something. Whether you're in a gang, the mafia, the family, the business, the hidden hand, Illuminati, the whatever, you're in it. I mean, unless a higher up allows you to you know, get blasted out, crashed out, jumped out, there's always a penalty. If you use their words, you are one of them. Signs, symbols, etc. Let's go.
In fact, the entirety of WAC 308 to 100 is a mandate to the State of Washington Department of Licensing, directing the issuance of a commercial driver license and no other kind. However, one may escape this tenebrous licensing scheme if an automobile qualifies as a recreational vehicle primarily designed for travel use. WAC 308-100-210. The term recreational vehicle shall include vehicles used exclusively for non-commercial purposes which are 1. Primarily designed for travel use. This too is elusive, as discussed earlier. The term travel is a broad, vague term with contextually expressed statutory meanings. Notwithstanding, every vehicle run on the highways was designed for travel in one context or another. Caution be had to recreational use as well, because recreational use also has business ramifications. For clarification, the Washington Administrative Code specifically defines the term recreational vehicle at WAC 308-100-210, which policy reads: WAC 308-100-210 Recreational Vehicle Definition. For the purposes of RCW 46.25.050, 1c, the term recreational vehicle shall include vehicles used exclusively for non-commercial purposes which are 1. Primarily designed for recreational, camping, or travel use. Note the use of the term vehicle. Vehicles have a commercial orientation when spoken in the language of statute. To be sure, there are many businesses that rent out motorhomes and motorcycles and minicars for tourists to fulfill their recreational muse. The law applied to motor vehicles. Babbitt Section 91, at 147 stating: Still again, subdivision of the last mentioned class has occurred, vehicles on 4 wheels perhaps, being placed in one group, and those on 2 wheels in another. Or perhaps, vehicles drawn by 2 horses have been made to pay one rate of license fee, and vehicles drawn by 1 horse, another. Where, then, in principle, is there any distinction when it comes grading or grouping automobiles into subclasses according to their horsepower, or the number of passengers they carry? It may be said of either class, that the large or heavy vehicle pays a license fee rated on some arbitrary basis. A commercial vehicle pays on a standard established for the class within which it falls, and the pleasure vehicle owner pays his license according to the VIC 1E which he operates. Dillon on Munn. Corp., 4th ed., Sector 682.
Y'all ready for the good part? Oh yeah. This is what, 4th edition in secundum. So this is law. This is law. This is not hokey poke. This is not jazz. This is the law. This is American law, American jurisprudence, court cases already, Supreme Court settled, adjudicated. These are facts. They don't seem to deal in facts. That's why they hate it when you bring them in there. They deal in assumptions and squishy bottom of a mucky lake water maritime rules done in the muck, where they can move the goalpost on you. But the real law stands to the test of time and to the storm. This is what it is. Your vehicle, when used and made properly, deregistered, is a pleasure vehicle. It's an automobile. It's a personal automobile. So let's see what they got to say here next. Let's go.
Anybody can join any one or several of the classes as he chooses.
So did you hear that? I've been telling you guys this since day one. You can jump between private or public as you see fit. They do it all the time, but they've been generally keeping us and classifying us as public. Your taxes, public. Your house, public. Who owns it? Public. Your vehicle, public. Your kids, public. So then they can get involved in all that. They are not supposed to be involved with your kids, your offspring, your house. You're nothing. Matter of fact, them taking your house at any point in time, if you've put money on it and they have the promissory note that you originally signed as collateral, they've been paid. They can't, if they do it on, I don't give a rat's ass if they say, oh, well, we can do a non-judicial foreclosure. Yeah, you can do it, but that doesn't mean that you can't sue them over it. It's unlawful. Then give me back my note, and I want the cash value. No? All right, well, then I'll sue you for it. The house and the note.
Chooses. A personal automobile may be used for personal reasons on the roads and ways as long as that use is not and does not cumulate to trade, traffic and transportation. This was expressed in the cases of State v. Scheffel, Chicago v. Gall, Chicago v. Banker, and Howard's Yellow Cab as it is, by intent of the whole act. Giving respect to the rule of exclusion, it was equally stated by the Marr Court, while the factual basis of Marr is not precisely adjunct to this discussion, the theoretical resonance is the same. From the language of the statute, one can legally travel as long as he or she does not engage trade or traffic for compensation. One's personal automobile is his personal property, the same as the shoes on his feet, and as such, may be used to his personal indulgence, not being in service for hire. From the language of the ordinance, one can legally beg as long as he or she does not do so aggressively. Spokane vs. Marr 129 WN App 890.
Did you hear that?
He exemption.
It's kind of an interesting. Oh, man. What happened? Oh, I closed the window. Okay, hold on. Still recording. I'm gonna have to bring it back up. Oh, dang it. All right. So, but that's anyway. So that's interesting because it says you can legally beg as long as you're not aggressive. So then how are they getting people for panhandling and whatever else unless they're doing it illegally, aggressively, or they're not really. I mean, I guess it does. It didn't say if you have money that you can't do it. It is deceptive, but I guess you can beg legally. Did not know that. Maybe you're. I mean, that's interesting. All right, so let's open. Oh, we're doing that. Oh, don't tell me it's gonna. All right, bear with me one moment. So, as we finished up that almost last section, it would seem that I don't know, something happened. Computer decided to go sleepy time for some odd reason. So, that being the case, there was one last sentence, paragraph in there. It says, one's personal automobile is his personal property, as the same as the shoes on his feet, and as such may be used in his personal indulgence, not being in service for hire. For the language of ordinance, one can legally beg as long as he or she does not do so aggressively. Spokane versus Mar 129 WNAPP 890. The last part before the very last video, which is titled Anatomy of Traffic Infraction. That'll be the last section we're going to cover. That's the whole document. Before that, it says the exemptions provided for in Section 1 of the Motor Vehicle Transportation License Act of 1925, which would probably be a really good book to get. Stats 1925, page 833. In favor of those who solely transport their own property or employees or both, and of those who transport no persons or property for hire or compensation by motor vehicle have been determined in Bacon Service Corporation case to be lawful exemptions. In Schmolke 199 CAL 42 1926. It has already been clearly established. So it wasn't that we were getting lucky with our court cases. We were just standing up for our rights and winning these lawsuits, winning these court cases. This does not by any means mean that you can just operate in any kind of way you want. You can speed, you can do whatever you want. No, it does not mean that. I've never said that, not one day. What it means is that if you are a responsible adult, not feral, not trying to hurt anybody, not trying to speed and endanger public safety, you have a right to do these things. You have the right, but you can lose or waive that right depending on what you do. If in fact you are not a grown, actual man, grown woman, grown private individual. And then they'll just arrest you and take and tow all your stuff because they have the right to do that when you decide you're going to waive your right to endanger the public or yourself or whatever else. Then you waive it. All right, guys, that's it. I'm going to try to see if I can restart the computer and wipe some stuff. I don't know if what happened, but can't stop, won't stop. We're going to keep going. So that's the end of this video, but I will fire up the last section and then we're all done with that. Other than the final video for Right to Travel on how to do it properly. I'll make that video. I'll try to recover everything I know. And then that'll be it. So I'll talk to you guys later. Peace.